I actually am now more concerned than ever. So we've got this whole book and quite a bit of dispute under the law about what satisfies the definition of legal detention, correct?
I don't know if there's dispute about it, but because
But there's debate about it. You said that when you laid your comments out a moment ago.
Certainly, because there's so many different factual possibilities that could occur. The courts have to apply the general rules to those specific cases. And they do that quite well in the absence of a definition of those terms right now.
And I recall very, very clearly in law school quite a bit of our criminal law teaching revolving around the definition of these probable cause, reasonable suspicion, and certainly reasonable and legal and very intelligent minds can differ on what constitutes a showing of reasonable suspicion or probable cause under the law, right? I mean, there's quite a bit of...
That gets litigated frequently
yes.
in motions to suppress and things like that in criminal courts.
Yes. So my concern is we've got a situation where a person has been, quote, lawfully detained. And let's say, for the sake of argument, that reasonable minds can differ on what constitutes lawfully detained. And we can't define it because it takes a whole book to define it. We can't put a simple little definition in our statute that defines it. And let's say that I'm a DPS officer, or I'm a police officer, or I'm a county sheriff, and I've detained someone, and in my mind, I've lawfully detained them, and therefore, I have the opportunity and the ability to ask them for their legal status. Let's say that person actually is undocumented, and I turn them over to the immigration authorities, and the person gets deported. Later on, it's determined that I really didn't lawfully detain that person. But then it's too late, right? For that person.
I don't know. I mean, you could put what I know about immigration law in this cup. So I don't know if immigration courts undergo the same analysis that we do in criminal law, having to do with whether or not the person was legally detained, those motions to suppress that I talked about. I actually don't know if they do that in immigration courts or not. So I don't know if you...
Can I say that one day, if I may, just to follow up? You're absolutely right. What happens is, because I do criminal practice, if you don't have probable cause, but you arrest someone and they go to jail and they're checked, INS places a hold on them. But if you're a U.S. citizen, you have a right to a hearing on your motion to suppress, where you can get the case dismissed if there was no probable cause, or there's. I mean, that's the way it works. You don't get the same rights in immigration courts. Once you're arrested, whether the arrest was legal or not, or there was probable cause or not, but once you get arrested and get booked in jail, you're not in this country legally. There's a detainer placed on you, and you're not eligible to be bonded out. That's the way it works.
Thank you. Following up, Mr. Chair, when you laid the bill out and you talked about your intention, you talked about making sure that if someone you actually used the words probable cause in describing to me what your intention was when someone's lawfully detained. I would advocate that if that's what we're looking for, is that we want to make sure that if there's been probable cause demonstrated that a person has committed a crime, and therefore we should have a heightened investigation into whether the person is in our country legally, that's one thing. But if what we're trying to do is simply create a catch-all provision that's going to allow immigration status to be checked, regardless of underlying reasons for doing that, then this is the language we would want to keep. Because it is so broad, and there is so much reasonable debate under the law on what constitutes a lawful detainment, that what can happen now, the opportunity that will be created here is local law enforcement authorities can, quote unquote, lawfully detain someone. And maybe they didn't lawfully detain them, but they made the argument that they did, and because they made the argument that they did, they then check their immigration status, off that person goes to Mexico or Africa or wherever they're from, and it's too late for that person now. And essentially what we've done is we've created a police state where we're giving an enforcement opportunity to local law enforcement to detain a person under the argument that they're lawfully detaining them for purposes of checking their immigration status and deporting them. If what we're trying to solve here is making sure that people who are in our state who are potentially committing crimes and causing problems for our community, which I think is where our resources would more legitimately be steered, then I would think we would want to tighten this and use a probable cause definition at the very least, and also be very clear that we're not just talking about having detained someone for purposes of investigating a criminal offense where maybe they're a witness versus the person we suspect of being a criminal. Then we would be getting more toward, I think, what it is that you stated your intention was under the bill that you've advanced. But I'm very concerned that we've gone way beyond that because of the way the language is written here.